Today, we are strapping in for what is, I think, perhaps the most critical legal and ethical high-wire act in medicine, navigating consent and capacity for high-stakes decisions here in the UK.
Right.
And look, this isn't just about ticking a box on a form, is it? It's the absolute legal foundation for everything you do.
Everything, from prescribing a tablet to planning major surgery.
Exactly.
And that's precisely why we're here. We are, trying to take the heavy lifting out of those really dense legal documents.
Right.
We're distilling the core requirements from, well, 3 massive regulatory pillars: the GMC's guidance, the landmark Supreme Court judgment of Montgomery, and most critically, the Mental Capacity Act 2005.
So this deep dive is really a shortcut.
It's a direct shortcut to mastering these principles, and this is material that's just crucial not only for complex patient care, but for anyone facing high-stakes exams right now.
Our mission, then, is to give you a definitive map for navigating the 2 critical pathways of consent.
Exactly. When capacity is present and when it is, definitively lacking.
And to help you avoid those common legal and ethical pitfalls, the ones that compromise patient safety, autonomy, and frankly, your own professional standing.
And we have to begin with the foundational truth, the one-sentence takeaway that should just guide every single decision you make.
Okay, what is it?
Consent is only ever valid when it is voluntary, informed, and given by a person who has capacity.
Simple as that.
If any one of those 3 things is missing, if they're pressured, if they're uninformed, or if they lack capacity, the consent is invalid. And you have to proceed down a completely different legal framework.
Okay, let's unpack this then.
Yeah.
Before we even ask for permission, before we bring up a treatment plan, you're saying we have to start with capacity.
Always.
Why is it the absolute gatekeeper, and what even defines it?
Well, the law is so strict because capacity protects a person's autonomy. I mean, if someone lacks it, the law has to step in to protect them.
Right.
But the key thing to understand is that capacity is not some global trait. It's decision-specific and it's time-specific.
So you mean someone could have capacity for one thing but not another?
Exactly. You might have capacity this morning to decide on your lunch, but lack capacity this afternoon to consent to a major operation if you're, say, delirious from an infection.
So you assess it for that decision at that time?
Precisely.
So what are the precise abilities we are legally required to test for?
Okay, so there are 4 key abilities, and the patient has to demonstrate all of them. 1, the ability to understand the relevant information, risks, benefits, alternatives.
Okay.
2, the ability to retain that information for long enough to actually make the decision.
Right.
3, the ability to use or weigh that information. This is often the hardest part to test. And 4, the ability to communicate your choice. And that could be verbally, through sign language, even by blinking once for yes.
That weighing requirement, how do you test that in practice? It feels so subjective.
It is challenging, but it's crucial. You're not testing if they weigh the risks correctly in your medical opinion.
Right.
You're testing whether they're engaging with the concepts logically based on their own values.
Can you give an example?
Sure. So if a patient says, I understand that without surgery I might lose my leg, but my religion forbids blood products, and I believe saving my soul is more important than my leg, they're weighing the information.
That's capacity.
That's capacity. But if they say, I understand the risks, but I believe the government is trying to poison me with the anesthetic, well, they may be struggling to use and weigh the information rationally.
Because of a disturbance of the mind.
Exactly.
And the law governing all this is the Mental Capacity Act 2005. It gives us 5 foundational principles that are, well, mandatory.
Completely mandatory.
Let's run through them quickly, because this is the legal bedrock. Right?
Absolutely. Non-negotiable. First, always presume capacity. You have to start from the position that the patient can decide.
The burden of proof is on the clinician.
Correct. Second, always support decision-making. This isn't just a nice thing to do, it's a legal duty. Give them a quiet space, get an interpreter, use pictures, give them time.
Okay.
Third, and this is the big one, unwise does not equal incapacity.
The major pitfall.
The biggest. Just because a patient makes a choice you profoundly disagree with, even a choice that seems terrible for their health, it does not mean they lack capacity. It protects their autonomy.
Right. And fourth,
if and only if capacity is definitively lacking, then you act in their best interests.
and finally,
Fifth, any action you take must be the least restrictive option of their rights and freedoms.
so we have this principle of presumed capacity, but when we have doubts, we use the formal MCA 2-stage test, What does that actually look like on paper?
You have to show two things, and they have to be causally linked.
Yeah.
Stage 1 is there an impairment or disturbance of the mind or brain?
The medical cause.
Yes, delirium, intoxication, sepsis, severe dementia, whatever it is. And stage 2 is the patient unable to make this specific decision because of that impairment?
Ah, the causal link.
That's where you test the four abilities. If the inability to understand, retain, weigh, or communicate is caused by the delirium, capacity is lacking. If they're refusing treatment due to deep-seated beliefs and there's no underlying impairment, capacity is present.
No matter how frustrating that decision seems.
No matter how frustrating.
So the key takeaway here, the most legally defensible practice, is always to check, support, and rigorously document that capacity assessment.
Using the two-stage test.
Before you go down either consent pathway, that assessment is your legal firewall.
It absolutely is.
Okay, here's where it gets really interesting, because we have these two paths that diverge. Once capacity is confirmed, we go down pathway 1. That's governed by the Montgomery standard, which, I mean, it completely overhauled informed consent about a decade ago.
It really did. Historically, the standard was what a, reasonable doctor would tell a patient. Montgomery, in 2015, flipped that entirely to the patient's perspective. It established that the clinician has a duty to make sure the patient is aware of two key things.
Okay, what are they?
First, the material risks of the treatment, and second, all reasonable alternatives.
So how does that change the discussion? What makes a risk material?
Well, a risk is material if, first, a reasonable person in that patient's position would likely think it's significant, so common or severe complications.
Okay.
But second, and this is often more important, if this specific patient would attach significance to it based on what you know about them.
So you have to tailor it.
You have to. For example, a concert pianist would probably find a 1% chance of minor finger stiffness, a material risk for a wrist operation. A librarian might not. It's about what matters to them.
And the requirement to discuss alternatives is just as important, isn't it?
Oh, absolutely vital. You have to discuss all reasonable alternatives. And this is where a lot of people fall down. They forget that the most important alternative is explicitly the option of no treatment.
Right, non-operative management.
And what the natural history of their condition will look like if they just do nothing. Shared decision-making means giving them a real choice, not just asking them to confirm your preferred option.
I think having a practical conversational model for this really helps.
It does, yeah. A great way to phrase it is something like, based on what you've told me about your lifestyle, the risks people in your situation often care about are X and Y. Let's talk about those. We also need to talk about alternatives, like physiotherapy. And we can also choose to do nothing. Here's what that would probably look like.
That really opens the door for genuine patient input.
It does.
Okay, now let's pivot to pathway 2. Capacity lacking. So if capacity is definitively gone, the treating clinician makes the decision, but only under the MCA's strict best interests framework.
That's the key. This isn't paternalism, it's a guided legal process. You can't just decide what you think is clinically best. The best interests decision needs a systematic approach. First and foremost, you have to consult those close to the patient family, carers, to find out the patient's past wishes, beliefs, and values.
So you're trying to make the decision the patient would have made?
As closely as possible, yes. To honor the person they were before they lost capacity.
But before you even talk to family, there's an urgent duty to check for specific legal documents, right? Ones that carry more weight than family opinion.
Correct. You have to check urgently for two binding documents. One is a valid and applicable lasting power of attorney for health and welfare, or LPA.
The legally appointed decision maker.
Yes. Or an advance decision to refuse treatment, an ADRT. That's the patient's prior decision to refuse a specific treatment. And if they're valid and they apply, they are legally binding. They trump everyone's opinion.
And what about advocates? Especially if the patient is on their own.
Yeah, good question. If the patient is unbefriended, so no family or friends to consult, and you're making a serious treatment decision, you have a legal duty to instruct an independent mental capacity advocate, an IMCA.
And their role is?
The IMCA represents the patient's perspective in the best interests meeting. And finally, when you make the decision, you have to choose the least restrictive option that still meets their needs. This is where things like DOLs come in.
DOLs, deprivation of liberty safeguards. That's a heavy term. When does a decision cross that line?
It's when the patient is under continuous supervision and control, and they aren't free to leave, usually for their own safety or for treatment. If your best interest decision means keeping a patient on a locked ward, That decision has to be legally authorized by a Dole's assessment.
It's a check on that fifth MCA principle.
Exactly. Making sure we are always using the least restrictive option.
Okay, let's shift to the pressure cooker scenarios. The places where these rules can feel like they clash, especially in emergencies.
The clinical ethical tightrope.
Yeah. Scenario 1. Emergencies and ADRTs. If a patient is deteriorating fast, what's the rule?
The rule is clear. Provide immediately necessary treatment to save their life or prevent serious deterioration.
But the conflict comes when you suspect an ADRT exists, or the family mentions one, but you don't have it in your hand.
Yes, and the source material gives a fantastic example of this. A delirious patient needs urgent surgery. You think there might be an ADRT, but you can't find it.
What's the right action?
The ideal action is to proceed now in the patient's best interests, give the life-saving treatment. But you continue to check urgently for that ADRT or LPA in parallel.
And you document everything.
You document your rationale immediately, that the delay caused by searching would risk their life. The trap is delaying life-saving surgery to wait for signatures. Treat first, document, and keep searching.
And only a confirmed, applicable ADRT would stop you.
Exactly.
Okay, let's talk about children. Minors are complex because the line for capacity shifts with their maturity.
It's very age dependent. So 16 and 17-year-olds are presumed to have capacity, just like an adult.
Right.
For those under 16, they have to be assessed for what's called Gillick competence.
And what's the practical difference between being Gillick competent and having MCA capacity?
Well, Gillick competence means the child has enough maturity and understanding to comprehend the treatment, the risks, the alternatives. If they are, they can consent to treatment. But the legal waters get very muddy when a Gillick competent child tries to refuse treatment, especially life-saving treatment. In those situations, if the child refuses, but a parent or the court consents, the treatment usually goes ahead.
So the law keeps the door open to save a child's life.
Generally, yes. We should probably also mention the Fraser guidelines.
Which are a part of Gillick competence.
A subset, yes. They give specific legal criteria for advising under 16s on contraception and sexual health without telling their parents, as long as they meet certain criteria.
Right. Okay, let's nail down the 4 most dangerous traps for our listeners. The immediate disqualifiers.
Okay, trap number 1. Assuming incapacity because a decision seems unwise. We hammered this earlier, but it's worth repeating.
MCA Principle 3.
It's your firewall. You apply the 2-stage test, not your opinion. Trap 2. Listing only generic risks from a leaflet.
That misses the Montgomery duty.
Completely. You failed to tailor the discussion to the material risks for that specific patient. You didn't satisfy Montgomery.
And the third major trap, which happens all the time in busy settings.
Trap 3 is relying on relatives to interpret for consent. This is a huge red flag.
Why?
Because relatives might deliberately or accidentally misrepresent information. They have an emotional stake. They might not have the medical vocabulary. Consent is just not valid unless the patient is fully and accurately informed.
So always offer a professional interpreter.
Always, unless it is a true life-or-death emergency where any delay would be fatal.
And finally, trap 4. The one for the best interest pathway.
Trap 4 is the failure to do the required legal checks. So, proceeding with the best interest decision without regently checking for a valid ADRT or LPA.
You're ignoring the patient's legal voice.
Exactly. And you've breached your statutory duty under the MCA.
So what does this all mean when you're standing at the bedside trying to follow this whole auditable process? Let's bring it all together into a clear sequence.
Okay, the high-yield stepwise actions. This is what creates that auditable trail that's safest legally and scores highest.
Step 1.
1. Check capacity with the MCA 2-stage test.
2.
2. Support understanding. Use aids, an interpreter, give them time.
3.
3. If they have capacity, explain material risks and alternatives. That's meeting your Montgomery duty.
And 4, if they don't have capacity.
4. If capacity is lacking, urgently check for a valid ADRT or LPA, then consult the appropriate people, IMCA family.
And the final, crucial step.
5. Document everything. The assessment, the decision, your rationale, and who was involved.
Okay, to help cement those 2 pathways, let's go back to the frameworks. For capacitated adults, following Montgomery, we have consent.
Right. Consent stands for capacity first. Optional alternatives, including doing nothing. Needs and values, so tailoring the discussion. Specific material risks. Enable understanding. Note the decision. And talkback safety net.
Talkback safety net. What does that involve in practice?
It's that final check. You ask the patient to tell you, in their own words, what the key risks and alternatives are.
To make sure they've actually understood.
Exactly, to confirm they've retained it, not just nodded along. If they can't explain it back to you, you haven't enabled understanding, and your consent isn't properly informed.
Got it. And for when capacity is lacking, under the MCA, we have test by.
Test by is your checklist for incapacity. Two-stage test applied. Enable support first. Specific decision and time assessed. Treat emergencies. Best interests calculation completed. And involve others, LPA, IMCA, family.
So following these frameworks keeps you lawful.
And systematic. It ensures you don't skip those critical legal steps when the pressure is on. So, to wrap up, I think it's just so important to remember that in medicine, good documentation, it's not just bureaucracy, it is legal self-defense. The best professional protection you can have comes from fully documenting your MCA assessment, your consultation with others, and your best interest rationale.
Because if it's not written down...
If you can't prove you checked capacity or that you consulted the LPA, then legally it just didn't happen.
Precisely. And let's leave you with a final thought to mull over, building on that difficult emergency scenario.
Okay.
We talked about that core ethical tension. How do we balance the immediate duty to save a life right now in the Resus Bay with the absolute duty to respect a patient's documented refusal, an ADRT, when that legally binding document might only be found hours after you've already intervened?
Yeah.
That balance between immediate action and long-term autonomy, that is the ultimate test of clinical and ethical judgment, and it's one you must always be ready to face.
That is a profound thought. Thank you for joining us for this crucial deep dive.
We'll see you on the next one.